and we go. There we go. The recording is in progress. Now, in terms of the talk, where I'm going to start briefly is, as it says at the top of the slide here, where were we? So that's a quick recap of the decision of Miss Justice Roberts at the end of last year. What she reminded us all of is that compliance with the Adoption Agency's Regulations 2005 is mandatory. And her particular focus, of course, was on Regulations 15 and 17, which related to adoption medicals and the medical aspects of child permanence reports. She also pointed out, however, and confirmed as a matter of law, that a breach of those regulations does not automatically invalidate or render illegal a placement order that flows from a decision which has been reached where we have had a breach of or non-compliance with the regulations, and that the court has to look at, and the court retains the ability to look at the nature of the breach, so what was or wasn't done, and then determine whether the quality of the decision-making process has been critically or materially undermined. And if, as I'm sure you've read that decision, you'll be aware that she went on to look at what were called the cohort, the primary cohort children, and decide in relation to each child whether there was in fact sufficient information available at the time that the ADM took his or her decision, such that even though there hadn't been full compliance with the regulations, they knew enough and the court could be satisfied that the quality of the decision making, which had led to a placement order application being issued, and indeed a placement order being made for each of those children, was sufficiently good. So that was the state at the end of last year. The next stage, as I'm sure you all remember, is that on the 28th of January this year, Mr. Justice McFarlane, President of the Family Division, published his announcement in relation to the impact of non-compliance with the Adoption Agency's provisions concerning medical reports. And I've summarised here the two main things that came out of that announcement. The first was that if a local authority possibly could, they should await the outcome of what I've entitled Somerset 2, because he indicated that he intended to hear argument about the implications for the wider cohort of children involved in the Somerset litigation, and that you should only issue Part 18 applications for declaratory relief where you as a local authority were dealing with particularly urgent cases, and I've set out a couple of the examples there. You might recall that the secondary cohort of children in Somerset numbered into the hundreds, and so you can see why Mr. Justice McFarlane was keen to see if there was a way around dealing with hundreds and hundreds of applications. The next thing which we learn, and to anyone who either is within a local authority or is instructed on behalf of local authorities, it may not surprise you that it became clear that it's not only Somerset who had had some of these sorts of problems. I know certainly that, well, I was in the process of advising one local authority formally, and I had a couple of other local authorities waiting in the wings for Somerset too, and so I was lined up if needs be. And I'm sure that those authorities, as Mr. Justice McFarlane says in the Somerset 2 decision, were not alone. As he says, many, if not the majority, of the local authorities in England had been acting in breach of some aspects of the regulations. I think we can therefore safely say that if Somerset had several hundred, and you take the number of local authorities in the country, we were potentially looking at thousands of cases affected by the Somerset 1 decision. Now, in some senses, I appreciate that a lot of you will feel that this slide here is the start and the end of my talk. It is the main headline. It's the strict ratio of the decision. I've set it out, but it does bear repetition and a quick bit of discussion, which the main headline is that you should not, in almost all circumstances, be applying for declaratory relief where you have discovered that a placement order or an adoption order may have been made in breach of the regulations. And so on that basis, the President then dismissed the outstanding Part 18 applications, which of course were for several hundred more declarations. Has clarified in the next sentence, which has probably led to sighs of relief across local authority offices, that other local authorities do not need to issue similar applications. Goes on to state that, of course, he can't rule out the possibility that there may be breaches so significant that they do go to the validity of an existing placement or adoption order. But the route there is by application for permission to appeal out of time. And then the final sentence, which I've put in bold and italics because it is perhaps warning shot is unfair, but an indication from the President that the sort of applications which were seen in relation to the primary cohort children are not envisaged as being likely to be required in many circumstances at all. The indication is that you would effectively have to uncover almost an unknown health issue. And I suppose that perhaps explains the reasoning in the previous sentence of an application for permission to appeal out of time, because new information has come to light. It sounds, from my interpretation at least, of that paragraph 6, that that is what we are looking at. I said that in some ways that was the start and the end of the talk, it could be thought, but it seems to me that it's quite helpful to look at the reasoning in the Somerset decision. And the reason that I say that is because it is quite interesting, but also, of course, it's all well and good to know the ratio of a decision, but having an understanding of how that ratio has been arrived at is often very important. The first part of that ratio, set out in paragraph 24 and summarised on the slide displaying now, is that court orders are valid and enforceable unless and until another court order sets them aside. And we're all, of course, familiar with that if you think about it in very different contexts. Let's say that a court makes a without notice non-molestation order, and it then transpires at a later date that the court was not given accurate information and it made a non-molestation order in circumstances where perhaps it wouldn't have done if it had known the full picture. Well, it would be no defence to an allegation of breach of that non-molestation order that, well, I breached it because it shouldn't have been made in the first place. You still have to comply with that order unless and until it's discharged. And unsurprisingly, the President has confirmed that placement orders are no different in that respect. Where it becomes slightly more complicated or perhaps thought-provoking is the next two paragraphs, which the next two bullet points rather set out on this slide. The President draws a distinction between the local authority's internal decision-making processes of whether or not they will apply for a placement order or place a child with prospective adopters, and court decisions to make placement and adoption orders, and sets out that the local authority's internal decision-making processes are susceptible to challenge by judicial review, but the court decisions aren't. And of course, thinking back to what was on the previous slide about how the route of challenge to a placement order, if you suspect there has been an extremely significant breach of regulations, is through an appeal out of time. Well, again, if we step back and think about classic legal principles, that does make perfect sense. The next bullet point is the part which made me have to stop and think the hardest, and I don't know if I'm alone there. Quite significant reliance is placed on the concept of second actors. And I hope I've encapsulated that concept quite neatly in the bullet point there, but just to expand on it. The local authority and its internal decision-making processes are the first actor. And the court is the second actor. Generally, the second actor is entitled to conclude that the first actor has done their job properly. Thinking back to our example of the without notice non-molestation order, the court is entitled to assume that the regulations about and the law about without notice orders, i.e. the enhanced duty to be frank, has been complied with. And so that when the court has relied on what it's been told, it has acted in good faith. And it's a similar situation here. What the president is saying is that the court makes that, page down just a fraction too early there. The court makes that decision about whether to grant a placement or an adoption order based on the assumption that the local authority has followed its processes properly, unless the contrary is proven. And generally, the second actor has not knowingly done something wrong. The president also observes that there are strong public policy arguments in favour of status orders being voidable rather than void. And again, if you've ever had to trawl through the case law about the validity of a marriage, which may, for instance, it rises particularly with marriages conducted overseas, whether you've complied with all of the formalities and whether that marriage is entitled to recognition. There's a strong presumption in favour of orders and situations regarding status being valid, being upheld, and therefore being voidable rather than void. I'm sure that the distinction is familiar. It's there at the back of your mind somewhere from constitutional and administrative law lectures. If an order is void ab initio from the outset, it effectively is of no legal effect. But something which is voidable is valid right up to the point at which it is set aside, if it is indeed set aside. In terms of further arguments in support of orders being final and certain, if at all possible, and perhaps considering how could it be that there might be thousands of placement orders which should be set aside. The president also examined the case law relating to the finality of adoption orders. Those of you of a certain age may well remember the Webster litigation involving Mr. and Mrs. Webster and Norfolk County Council. In very brief terms, there were concerns that findings that Mr. and or Mrs. Webster had deliberately harmed their children were wrong. But despite those concerns, the adoption orders made were not set aside. But the point of that the president was therefore making was that, well, if something which had such significant effects for Mr. and Mrs. Webster, an adoption order being made in potentially unlawful circumstances, couldn't be set aside, then compared to that, a breach of the medical requirements of the adoption agency's regulations as compared to an incorrect court finding, you're talking about things of a very different nature, and it would be wrong in principle if failing to comply with the adoption agency's regulations could result in placement orders and adoption orders being set aside, but making findings which are potentially inaccurate couldn't. Third slide about the reasoning. As you can see, yet more. I couldn't quite resist the additional commentary there. But the other two factors which weigh quite strongly in the balance, certainly in my view, are that sections 21 and 47 of the Adoption and Children Act set out the gateway criteria, if you like, which have to be fulfilled in order for the court to be able to make either a placement order or an adoption order. And neither of those criteria themselves turn specifically on compliance with the adoption agency's regulations. And so drawing all of those factors together, the President came to the view that, as set out on that summary slide, that it will be very rare indeed for a placement order to be held to be invalid and need to be set aside because of non-compliance with the adoption agency's regulations. The next slide, but what about the decision in Re B Placement Order 2008 EWCA 835? And of course, the reason that I say what about that decision is because of the simple rules of precedent that govern our case law. If the Court of Appeal has taken a decision about when placement orders might and might not be susceptible to challenge, that obviously applying precedent and top trumps, the Court of Appeal will trump the President of the Family Division sitting in the High Court. Now, I'm sure that you all recall Re B in very brief terms, and the case does come from when we had adoption panels taking decisions about whether applications should be made for placement orders rather than simply agency decision makers. So it's before the streamlining. But the panel hadn't had all of the documents which it needed to see. In particular, there were some reports about the children's needs and about the parents' parenting, as far as I remember, which weren't before the panel. And I think one of them had been inaccurately summarised to the panel. And so the panel had taken a decision, but potentially on the basis of inaccurate information. This was flagged at the final hearing, and the implications of that error were explored in evidence. And the recorder tried to rectify them, and the recorder's reasoning in making the orders sought was that I have heard the evidence and I am satisfied that a placement order is right for these children. The Court of Appeal disagreed that that was the right thing for the recorder to have done, and determined that the application for placement orders should have been adjourned. The decision should have been remitted to the panel, and then the court should have gone on to consider whether to make placement orders or not. So let's look now at how the President resolved what might seem to be a tension between Re B suggesting that if there have been issues of non-compliance with the regulations or an unfair decision-making process internally for the local authority, correct thing to do is to bring things to a halt and then for the court to take a decision once the internal defects in the decision-making process have been rectified. Now, there are 2 points on this slide. This is obviously a personal opinion. I think the second point is stronger than the first. And it's the first sentence of that first bullet point which causes me some internal discomfort with my thought processes, I think is the best way of putting it. And that is the President's conclusion that it was relevant that the appeal in Re B was heard at a point when it was possible to set aside the placement order and return the case for redetermination, and that that will not always be the situation. I think it's possible to understand what the President is driving at there. If we think back to the Webster situation, clearly the further away in time you are from that defective decision making, and the more that has happened, children have been told perhaps about the decision, children may have been matched, they may have been placed, they may have been adopted. And of course, with each further step, the implications for the children of unpicking the decision become more complex from their welfare perspective. But I think that conceptually, knowing exactly how far away in time you should be from that initial decision making of the local authority is harder to fathom. Of course, it's going to be a spectrum, and there are going to be times when you discover the mistake so close in time that unpicking it doesn't have significant implications. But certainly to my mind, that's not the strongest argument, because there must be some defects which are so significant that it not quite never matters when you find them out, but that the passage of time is less significant. But I think the second bullet point there, and this is where we come back to the first actor and second actor theory, which I discussed a few slides ago. And that's the President's conclusion that there is a clear distinction between an order made by a court with its eyes wide open to the fact that there's been a serious breach of the regulations, and orders that are made when the court is in ignorance of any such breach. And as I said, to me, that seems the clearer, the simpler, the stronger argument. But my job today is not to argue with the President of the Family Division, it's to make sure that you and I are clear about what his reasons were and to make sure that we understand them. I think it's safe to say, at the risk of tempting fate, that Somerset are not going to be appealing this decision of the President, and indeed the arguments which the President had adopted are primarily those which were advanced on behalf of the Secretary of State, who'd been invited to intervene, and no party put forward any significant opposition to the Secretary of State's arguments. None of the parents were represented because all of the parents had opted not to participate in the litigation. Going back to the analysis of Re B, the first bullet point on this slide is, I'm sure, uncontroversial, because even Re B itself was clear, the Court of Appeal was clear in Re B that not every error leads to a placement order being set aside. It always depends on the nature of the breach, the extent of the breach, and the implications of that breach. And finally, again, tying back into the first actor and second actor theory, that the error which was appealed, of course, in Re B was the recorder's error, not that of the local authority. Yes, the initial mistake was the local authority's mistake in not ensuring that their adoption panel had the proper information, but the recorder, my words, compounded that error by not bringing proceedings to a halt and ploughing on and taking a decision. In terms of what to do if you are dealing with one of those very exceptional cases that we've been told the President really doesn't expect to come to court at all, it's not Part 18. apparently, Somerset were wrong to use the Part 18 procedure for the primary cohort children and the secondary cohort children. And the initial guidance, which we were all given by the President on the 28th of January, telling us to issue urgent Part 18 applications if we needed to, was also wrong. There it is. If you do find that you have got one of those exceptional cases, then your route is an appeal out of time. And of course, it is unlikely to be the local authority's application, because that would be the local authority appealing their own order, which they've obtained when they said they wanted it. The theoretical possibility appears to be either the guardian on behalf of the children or the parents discovering the errors and then appealing out of time. However, final section pretty much, and that is just to hammer home that the President has drawn a clear distinction between cases where potential breaches of the adoption agency's regulations are discovered before the placement order has been made, and cases where the error is discovered afterwards. And if you take two things away from the talk tonight, the first is that once you've got the placement order, it is pretty unlikely it will be set aside, even if there have been breaches of the adoption agency's regulations along the way. But the second is that if there have been breaches of the adoption agency's regulations along the way, and they are discovered whilst you are still in proceedings and the placement order has not been made, things have not changed. Somerset 2 does not change the fact that the right and good procedure to take is what is set out on the face of this slide here, and everything that we talked about in my previous talk. And that is, usually you will want the local authority is likely to want to retake the decision once they've rectified any defects in the decision-making process, whether that's in what the ADM has done, contents of the child permanence report, or otherwise. Second bullet point, that the local authority should consider itself under a duty to bring the breach to the notice of the court. Highlight, unsurprisingly, that it is likely that the court would want the breach to be remedied before the final hearing, because to do otherwise would risk falling into the error that the recorder fell into in Re B. And certainly in terms of the cases I've been dealing with in between Somerset 1 and Somerset 2, and I don't know if this chimes with other people's experience, that is still what is happening. If we've been discovering, despite the headlines which Somerset 1 generated, for those of us practicing in public law in childcare proceedings, that there are errors. Certainly I've still been finding that some summaries haven't been written by agency medical advisors, or that I don't think I've had any where there hasn't been an adoption medical, but certainly then we've been tending to highlight the error and ensure that the summary is inserted correctly into the child permanence report. And typically, in fairness to ADMs and local authorities, the stops have all been pulled out and cases have managed to be kept on track by and large, in my experience. Moving on in terms of breaches discovered pre-final hearing, and I think these are uncontroversial but important points to have in mind. If you're very close to your final hearing and there is no way of rectifying the defect before the final hearing, then frankly the allocated judge has got a difficult decision to take, and I suspect it is going to vary on a case-by-case basis quite how serious the breach is, because of course, going back to Re B, not every breach means that a court can't make a placement order. It will be a case of looking at the severity of the breach and the court deciding whether it's comfortable to make the placement order in any event. The final bit of guidance from the President set out in the last bullet point there. which again gives me a little bit of pause for thought. I can see that it is certainly a very sensible, pragmatic decision and approach. Approach is the right word, sorry, not decision. Because the president said, as you can see, that where no party, and in particular the parents, is aware of any health issue that might impact upon the determination of the placement order application, it may be that the court will proceed with the final hearing, but postpone making any final order pending receipt of the required medical information. I suppose the reason that I pause is twofold. A, that for those of us who represent parents, one can readily see that that's quite a difficult discussion to have with your client at what is already an exceptionally difficult time for them. But then secondly, and it will depend on the severity of the breach which has happened, but let's say it is one of those extremely unfortunate cases where, despite all the recent case law, no adoption medical has taken place. You still run the risk that at the adoption medical, something very untoward comes to light. And so you still run the risk, albeit a low risk, I accept, that this untoward information throws everything that was discussed in the evidence whilst you were waiting for the required information into a state of flux, and you may have to recall some witnesses. Now, I appreciate that's very much disaster planning. It's very much worst case scenario catastrophizing, but that is the potential shortfall of that route. And so, of course, that particular route will need to be considered very carefully on a case-by-case basis, perhaps bearing in mind how much you know about the medical history of each parent and any relevant siblings in particular. So I allowed myself 45 minutes just in case I wanted to talk for slightly longer than the half hour. I can see that something has popped up from Lorraine. Thank you, Lorraine. Lorraine's question is, the judgment says that even after a placement order has been made, local authorities need to comply with the adoption agency's regulations. So before a child is matched, breaches should be rectified. After they have been matched and placed, how far do you think that should extend? Well, Lorraine, my reading of the judgment is that it's effectively an ongoing duty. To an extent, that duty never stops. The duty to ensure that you have complied with the regulations. And clearly post-placement, but before adoption, you still have ongoing duties to comply with the regulations in relation to the adoption application. So I don't think I can give a very specific answer. And again, it's always going to depend on the precise nature of the breach that you discover, but it is always better to try and correct the errors for your internal purposes, even if it is months and months after they have been discovered. You're still going to be, from a legal point of view, on the ground dealing with the situation that unless that breach is extremely, extremely significant and really does change how things come across, you don't have to return the matter to court. And you don't even, as I read the Somerset 2 decision, appear to have duties to notify the other parties through legal routes. That would have to be a matter for a local authority to consider, depending on the severity of the breaches that they had discovered. So I hope that helps, Lorraine. I can tick that one off in the chat function now. Yes, Lorraine agrees with me. Great, and everyone can probably see that. I think I will stop screen sharing in that case. I've managed to make that work and not have to stare at my own face too much, which is great. Is there any other, sorry, grammar's gone at the end of the of a long day and a talk. Are there any other questions in our closing few minutes? Just wait silently and stare at the screen. No, I think I have bored everyone into submission. Well, thank you ever so much for attending, everyone, and I hope that's been helpful. The slides, if they aren't up on our website already, will be up on the website together with the recording of tonight's talk. And yes, thank you all for attending, and please, one last plea, fill in your participant questionnaires.